Now, let me ask you this. What if your daughters were to end up with somebody that they say they love them, right? And your daughter's completely in love, and that guy is hitting on them.
Judgment's sprung, in and out, the verdict swung. Oouchie Court Watch, we've just begun. Oouchie Court Watch, we're on the scene. Truth's unraveling, what does it mean?
All right, the parties on Gabriel, Zamora. And then after this, we'll take our break unless there's something else that's ready. Court is calling 2024 CR 011907, State of Texas versus Gabriel Zamora. Can I have parties announced for the record for the state?
Defendant for the state of Texas.
Defense.
Albertitis for Mr. Zamora?
And are you Mr. Zamora?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, and yes, we did.
Court will find that the state is in compliance with discovery. Mr. Zamora, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And off the record, and I do have Crispin, I'll take that up. We're back on the record. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
And indictment to correct previous convictions of defendants for assault to July 17, 2018. Furthermore, we're moving forward on count 2, only waive count 1.
And we have no objection to that, Judge.
Okay. Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault, family, household member with a previous conviction as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was.
Mrs.
Was.
Zamora, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 4 years in the prison. State is proceeding on count 2. There's a $1,500 fine. There is no application for deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be a mental health evaluation. State recommends community supervision. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to own? Did you understand with affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be 150 hours community service restitution, the BIPP course, TAP evaluation, and to follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count two in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
The time state moves to admit state exhibit one with attachments.
No objection, Your Honor.
All right, and state, have you talked to the complainant? All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments and review the same. All right, after reviewing states exhibits one and attachments, the court will find there sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor. We also have a request. His parents are here. They're divorced. He wants to live in Natalia with his dad.
Mhm.
So we would just ask if the court would give him permission to either report in Natalia, report here, but live in Natalia.
All right, how far is Natalia
About
from?
25 miles or so from here.
Okay, yeah, he can remain in Bear County. All right.
Thank you.
So are you employed?
I have my own business,
Doing what?
renovation.
Do you have any children?
I have 6.
What are their ages?
I'm about to be, it's 10 all the way to 2.
No, no, no.
10, 5, 4, 3, and 2,
All right. Boys, girls?
3, and 3.
All right. So the person you're accused of hitting, well, now that I've found you guilty of hitting and that you've pled true, I'm sorry, you pled guilty of hitting. Did you love that person?
Honestly, yes, I did at one point.
Well, I mean, when people say honestly before something, usually what's coming is dishonesty. So you hit her. Now, let me ask you this. What if your daughters were to end up with somebody that they say they love them, right? And your daughter's completely in love, and that guy is hitting on them. How do you feel about that?
Break my soul.
Well, so you broke somebody else's soul by hitting on their daughter. And let me just tell you, children learn how to speak and about relationship from their parents. So who knows? I hope it doesn't happen, but your daughter, if they've seen any of this or your children have seen you being abusive to any female, guess what they're going to think? They're going to think, well, my dad loves that person. So my husband, my boyfriend, if he hits on me, that's just showing that he loves me. And you know what the boys are going to think? They're going to think maybe this is how you show you love someone, or either they're going to think might makes right. That's how we win an argument. You beat somebody down. You're going to have to change your ways. Last time, the conviction that's here, somebody gave you 1 day in the Bear County jail for assault by deliberate injury. That's somebody else. What I can tell you in this court, and deputy will tell you, probation is not easy. Probation is not supposed to be easy. It's designed to rehabilitate. And you're going to have to start figuring out why you are abusive towards people that you claim that you love. You understand? There's going to be a $1,500 fine that's going to be probated. I'm going to sentence you to 4 years in the prison, suspended and probated for 5 years. There's 150 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, that will be deemed satisfied. How far did you go in school?
Like ninth grade.
All right, you're either going to, let me rescind that. So it's 100 hours of community service restitution. There's gonna be 50 hours will deem satisfied for parenting classes. And the remaining 100 hours, if you are in some sort of trade school and you complete that, then I will deduct the remaining 100 hours. If you do not, guess what? You're gonna have to work those 100 hours. You can either work those 100 hours for somebody else or work it for yourself. You understand?
Yes, Your Honor.
There's to be regular reporting by Zoom or in person, regular random UAs. He's not allowed to reside with minors. There's to be no unsupervised contact with minors. So with your children, in order for you to have contact with them, there needs to be an approved adult. Do you understand?
Yes, Your Honor.
There's an affirmative finding of family violence. There's to be no contact with Rosalind Torres. And there's to be proof of employment within 30 days. You need to get a job where you have a regular paycheck. You understand?
Yes.
There's to be no employment as a home healthcare provider or with minors. The BIPP course. And we'll do a TAP evaluation and MIC evaluation in custody. Follow Rex. And there should be field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Keep your hands to yourself
Yes.
and do not get into another relationship until you find out what is going on with you and why you behave the way you do. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
All right, on signs. All right, if y'all approach, why are we here?
Warrants, Judge?
Yes, okay, let me see. Ah, here we are. I have the supplemental. The paperwork is hiding from me today. It's hiding. All right, so they're recommending that you go to SATA.
It's not my understanding, Judge. My understanding was that they were recommending IOP and then staff and. whole
No,
staff and
what I
base.
have is that they wanted him to go to SATA. And this was signed on January 9th by me to have well, at least Angelini signed this for it says to have the attorney and defendant for a hearing on future conditions. And what they're requesting on the supplemental report, they say that felony drug court rejected you because they were not accepting new clients. And they're recommending that you attend SATA.
Judge-
Judge, if I may,
Yes.
so, that's what felony drug court recommended with SATA. A TAP was completed, and the recommendation from the TAP is instance of outpatient treatment, monthly urinalysis, and documented sober support meetings. We did receive a, court summary from the CFO, and the recommendation on the court summary indicates amend conditions for the intensive outpatient treatment, hold status in abeyance if he should fail to submit or test positive, to enforce that sober support meetings and weekly UAs for 90 days.
All right, if you drug tested today, what are the results going to be? You're going to get drug tested.
Be positive. I'm being honest with you.
All right, no. I appreciate your honesty. So how often are you using?
Once a week. I'm sorry to tell you, but yeah.
No. Here's the thing. I admire your honesty, but he's using once a week. That's not outpatient. Um, does anyone, would you like to call felony drug court and see if they'll have room for him?
I can do that, Judge.
All right, so he's gonna remain here in the courtroom.
Uh-huh.
He's gonna call felony drug court to see if they have room for you, because they were supposed to have more availability at the beginning of February. Because at the end of the day, you're using, I appreciate your honesty, but any use could be the last time you use. And I don't want you to have come to this court and you've told me you have these drug issues and I send you out. And then when I send you out, no. Oh, just,
No.
he just has to remain in the courtroom.
Okay.
Yeah. I appreciate that though. So the last thing I will want is for you to leave this courtroom. And when you leave this courtroom, I see somebody, a body in the field somewhere. And then it turns out that's you. Because that would mean that I could have done something to help you and I didn't do it. I don't think outpatient treatment is good for you unless it's through felony drug court, because felony drug court will see you on a daily basis. You understand?
Yes, ma'am.
So do not leave the courtroom. If you leave the courtroom, a warrant is going to be issued. You understand?
Understand.
So your attorney, he's going to call felony drug court, see if they have room for him, see if they have room for him. If the room for him is at the beginning of February, then I'll figure out something.
Okay.
All right. So he's going to call them, but remain in the courtroom.
Yes, ma'am.
Thank you, Judge.
All right, thank you. But yeah, no. I appreciate that. I want them to be ready.
Hey, I'm glad they just keep getting him, not me. That's all I'm saying.
Yeah.
I got my house, I got my dog, I got things going on right now. I just can't just leave this like on my house payment, I got my bills to pay, I just can't just go and not pay nothing. When I come out, I'm gonna have nothing, I'm gonna be homeless.
No. Here's the thing. You're assuming that they are going to say inpatient treatment. What I'm telling you is they may not, but the way you're headed right now,
Sure.
there should be a motion to revoke file because you're using. But so I am trying to help you.
Okay.
Your attorney's trying to help you. I don't want to revoke you. I don't want a motion to revoke filed against you. I'm trying to help you. I think it's best for you to go in custody because you're still using. Felony drug court will interview you. They're probably going to accept you. Your attorney can bring documentation to them showing them that you have outpatient treatment lined up. But with outpatient treatment, you can still use. In my court, I'm not a treatment court. I could have you come here every single day for testing, not on the weekends. Felony drug court could see you on weekends because they have the personnel for that. In order for me to even have you tested, I would have to send you out to get testing because they don't have any more cups here because of finances and cutbacks. So you should probably go into custody today, and then felony drug court will probably accept you on Thursday. If felony drug court decides not to accept him, then we'll do something else. But the latest you'll be in custody is Thursday. And what I can tell you is, counsel, we can take him in custody today, and I will actually put him on my docket for Friday. Because if nothing happens, then I will take care of him and you'll be released on Friday by me.
Can I say something to that?
Sure.
Can I put my orders in the ferry, like my house, and my dog, everything that's going on with me in my life right now? I just can't be put in jail right now.
I mean, you have family members.
I mean, huh?
You just told me you have family members.
I do have family members.
Mhm.
I do, I mean, I need to, if I'm gonna be going through 2 days, it's kind of, like you said.
All right, do you have the number to his family members? You say you have a dog?
No, dogs, I have dogs and my daughter, and my daughter's already growing up. I'm already 50 years old. I'm already
How old is your daughter?
28.
No. Because you're using on a regular basis and it's meth. You never know what's going to happen. Okay.
Yes, ma'am.
All right. So he'll He'll go into custody today.
Okay.
We're gonna do the referral for felony drug court. And then I'm gonna set this back in this court on Friday, because if nothing has happened, then we'll do something else. And then I will strongly consider the outpatient.
Okay.
But if you could, if you will make a copy of that,
Yes.
and Ms. Abrams, if you could
Need my
email
medication
that
or-
to felony drug court.
What medication are you on?
Heart medication,
And Judge, he's on some
heart
heart
medication.
heart medication. He
Okay.
had 2 heart
Heart
attacks
attack.
last week, so, last year.
Mhm.
So, he also needs his medication, so I don't know
That's why I need to get my
how we
email
intend to get that resolved as well.
All right, where's your medication?
at my house.
Why would you come to court without medication?
I don't think I really took it this morning.
All right, so I will tell you, using meth is not good for your heart.
I know that, man, I know that.
And
Mhm.
I think that's been communicated to him, Judge.
Okay. All right, so then this is, you need to turn yourself in today to the jail. If you don't turn yourself in today at the Bear County Jail by 5 p.m., then a warrant is going to be issued for your arrest. So you say you want to get your medication, he can get his medication.
I mean, I can give him a little bit more time to get my orders in there, like,
No. I've already made my decision. My decision is he can go home to get his medication. He needs to report to the Bear County Jail no later than 5 p.m.
Where's
Thank
the
you.
court? Thank you.
All right, you're welcome. All right, James Ross. All right, you've been appointed,
Yes, Judge.
and what I can do, I know you said you want a bond reduction.
Well, Judge, I guess my understanding is that you had remained with him without bond, and I did want to approach regarding the status of his bond. He was asking that it be reinstated.
Oh, the bond, you'll have to speak with the bondsman on whether or not the bondsman wants to reinstate.
And I
his-
did just get off the phone with Cowboy Bail Bonds,
Mhm.
and they were looking, I don't know if there's, she was not aware, the person I spoke to, was she looked through the notes of any affidavit to surrender.
Mhm.
And so they said they didn't have an issue with, they still are on his bond, is my understanding. They had did a reinstatement back in December,
Yes, bond reinstated,
Right.
so it was recalled.
but they're not aware of any affidavit of surrender surety. I don't see that there was one that was.
All right, so you're saying he has a warrant out?
Well, my understanding is that he was here in court on the 13th and that he was late, and when he
Oh, yeah.
appeared that he had remained with him without bond, and so I didn't want to address that and ask.
All right, have you conferred with the state on that?
I have, Judge. I spoke with-
And actually, no, if I remember this correctly, the bondsman got off his bond.
No, I was just gonna interrupt you.
Yeah, the bondsman got off his
Okay,
bond.
and I did call them just right now, and they were looking through notes, and so they didn't see it. I need to, I guess, look at.
No, so the bondsman got off of your bond. So you probably want to tell them that's in the notes. That's why he was taking it. He came late. And I would have issued a bond forfeiture, but have attorneys on his late attorneys on his late arrival. But then before any of that was done,
Okay,
the bondsman filed a affidavit to surrender surety. So that's the bondsman who's not on your bond.
okay. Well, so I'll speak to them. I guess I need to check with the clerk's records because I did not, they were not aware of that when I spoke to them.
And so when would you like this recalled for you to review?
As soon as I can, I know that I'm gonna be in trial next week. Judge, he would like to address the court.
Yes.
Greetings, yeah.
Mhm.
I apologize for being late that day.
No. Here's the thing. We're past that point because the reason why you're in custody is not because you were late for court. The reason you're in custody is because your bondsman no longer wanted to be on your bond. And I saw, it was in order. So I signed the affidavit to surrender surety. So that's why you're in custody.
Okay. All I've been able to see is that I've been remanded without bond. And
What I'm telling you is the bondsman got off your bond. So he'll need to a new bond will have to be set if that's what your attorney wants, and we'll have to set that on a different day.
When I spoke to them as well, they told me that they were still on my bond. The reason that they told me also that they.
All right, so does anybody want to pull? I am telling you, my mind is a steel trap. And what I'm
understand.
telling you is your bondsman got off your bond. We can
Yeah.
have it. Here's the thing. I want you to understand something. We can continue to have this conversation, but it's not going to go anywhere. We're not going to finish the marathon. The reason why we're not going to finish the marathon is because what I'm telling you is the bondsman filed an affidavit to surrender surety. I know what they're saying. They told your attorney, but I'm telling you, that's the document I received. I signed it. So your bondsman may need to file an affidavit to restore the bond. I haven't received that. That's what your bondsman need to do. Okay? So that's where we are. No hard feelings about you showing up late for court, because guess what?
You'll never
We're all,
happen again.
here's the thing, we're all adults. If people want to, if defendants want to stroll into this court at 11 or 10 or 9:05, they can. But there are consequences for that. You understand?
So those kinds of-
All right. So when do you want this call back?
That's the question.
Sure.
So you don't have me remanded without bond?
Okay, so
understand.
here's the thing. You need to talk to your attorney
Yeah,
about that,
let's-
because I've explained it.
I mean,
All right, so
You have been
how much
informed.
time are you asking for to bring this back?
Just a week, Judge.
All right, Ms. Fergus, can you recall this in 1 week, please?
Yes.
And here you are.
Thank you, Judge. I am actually supposed to be here for sentencing on Thursday. So if I
Okay,
was planning to step away if we were in trial.
all right,
Like
Norma,
the-
if we can bring this back on Thursday?
Yes.
Yes. All right, we'll be back on the 30th.
Thank you, Judge.
And now you have that document, so now you know the bondsman needs to file a affidavit asking to restore your bond.
We'll address it then. Thank you, Judge, for your time.
You're welcome.
Oouchie Court Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie Court Watch, quick as a flash.